Good evening. I'm Lord Justice Coulson, and I have the honour of being the Treasurer of Gray's Inn for 2024. So you will have worked out I've got a month to go. And I must say it has been one of the great honours of my life to do it. A very warm welcome to all of you in Hall tonight. Also a very warm welcome to all of those of you around the country joining on Zoom and online. I know we have a large group of students in Liverpool, and that's where our Director of Education, Tony Charles, is. I hope keeping them in order, but they are also very welcome. It's a great personal privilege for me tonight to introduce the speaker for the Birkenhead Lecture, Lord Dyson. Many years ago, in the mid-1980s, if you can imagine that there was such a time, I was the junior tenant in what became Keating Chambers, and John Dyson was one of our young silks. And he was extremely kind to me in a number of ways that he has obviously long forgotten. But as you students know, you never forget the kindnesses that are done to you when you're young. And John's quiet encouragement seemed to see something in me that I'm not sure I could see myself. And I've always been very grateful to him. Having conquered construction law, John went to become head of chambers at 39 Essex, where he became one of the outstanding public lawyers of his generation. He then became a Queen's Bench Division judge in 1993. In 1998, he became the judge in charge of the Technology and Construction Court. And many years later, I was very proud to do that job as one of his successors. He began the reform process which the court needed and which has resulted in such a successful court now. He became a Lord Justice of Appeal in 2001. In 2003, he was the Deputy Head of Civil Justice, another job which I one day did after him. In 2010, he became a Justice of the Supreme Court, and in 2012, he accepted the appointment for the job which many of us thought he was born to do, which was to be the Master of the Rolls. And he did that for 4 years until he retired in 2016. Now that's the conventional list of John's various appointments. But that list doesn't tell anything like the full story. In fact, in some ways it obscures it. Some judges, when they are appointed to those huge jobs with the great responsibilities and duties that go with it, sometimes find that they do fewer judgments, and sometimes those judgments are perhaps not all that they might have been if they hadn't had all those other responsibilities. Not John. Despite all the responsibilities that he had, time and again you read a judgment by John, particularly when he was Master of the Rolls, and you marvel at its clear analysis and the simple, straightforward points that he makes. Any of you students, my advice to you is, go out, find a judgment of Lord Dyson's at random, and you'll see what I mean. He is one of the most frequently cited judges of any judges of the last 20 or 30 years, and it is because his judgments are so clear that even I can understand them. And that's quite a high bar. Ladies and gentlemen, Lord Dyson.
Well, good evening, everybody. Peter, thank you for those extraordinary remarks. I've got a strict timetable. I don't even know there's somewhere I can put my watch, so I don't know who's going to keep an eye on the clock. I will try and balance the watch there and hope it doesn't fall. I'm going to go straight in because time is short and there's quite a lot I want to say. It's lovely to see Lady Hale here in the front row looking at me, and I start by saying that on the 3rd of April of this year, Lady Hale, by now retired from the Supreme Court, wrote an open letter to the Prime Minister, which was also signed by 2 other retired Supreme Court justices, 4 retired judges of the Court of Appeal, and more than 600 senior lawyers. It was published in the press and was a lead story on the BBC News. It said that the situation in Gaza was catastrophic. On the question of the UK government's supply of arms to Israel, the letter said the International Court of Justice's conclusion that there exists a plausible risk of genocide in Gaza has placed your government on notice that weapons might be used in its commission and that the suspension of their provision is thus a means likely to deter and/or a measure to prevent genocide. The authors of the letter said the UK must take immediate measures to bring to an end, through lawful means, acts giving rise to a serious risk of genocide. Failure to comply with its own obligations under the Genocide Convention to take all measures to prevent genocide which were within its power would incur UK state responsibility for the commission of an international wrong, for which full reparation must be made. A piece in The Guardian, immediately following that, said the letter's significance lies not just in the number of signatories, but the fact that it has been signed by senior retired judges who normally shy away from commenting publicly on issues that are politically sensitive. The letter was criticized by Joshua Rosenberg on the grounds that it seriously misrepresented the decision of the International Court of Justice of the 26th of January 2024, in that the court did not find that there was a plausible risk of genocide in Gaza. Together with many hundreds of senior lawyers, including judges, I signed a counter letter pointing out this error. As Joan Donoghue, the president of the court at the time, said, the court decided that the Palestinians had a plausible right to be protected from genocide, not that the claim of genocide was plausible. Now, I do not propose to discuss in this lecture the important question who was right and who was wrong about that. But I think it provides an arresting illustration of the issue that I do wish to consider, which is whether there should be any, and if so, what limits on what retired judges may properly do or say. The media reaction to the open letter provides striking evidence that what retired senior judges say about important issues of the day, particularly legal issues, is of real interest to the public and is for that reason important. If a journalist or academic had written that letter, it would surely not have attracted much media interest. There used to be a convention that once appointed, judges could not return to private practice as a barrister or solicitor and would not provide services on whatever basis as an advocate in any court or tribunal in England and Wales or elsewhere, or provide legal advice to any person. This draconian convention reflected a long-standing, strict view about the behavior that was expected of judges, perhaps best encapsulated by Lord Hailsham, Lord Chancellor at the time in 1970. He said, I venture to tell High Court judges when I interview them before appointment that I think they should approach the bench with the enthusiasm of a bridegroom approaching marriage or a priest approaching priesthood. A sentiment redolent of a bygone age and expressed in suitably archaic language. He was reacting to Sir Henry Fisher's resignation from the Court of Appeal in order to work in the city. In a slightly different but equally strict vein, United States Justice Felix Frankfurter said in 1970, how foolish for a justice of the Supreme Court ever to venture from the bench and accept invitations to speak. In 2005, Lord Faulkner, Lord Chancellor, informed the Lord Chief Justice that he had decided that retired judges below High Court level should be able to return to practice. This provoked a strong negative response in the report of the Judges' Council Working Party, which included the following. The major objection of principle to removing the current prohibition is that if return to practice becomes the norm, or something which was overtly permitted or encouraged, it would inevitably diminish the standing of the judiciary and seriously weaken its independence. It may be the case that ex-judges can be relied upon not to abuse their position or to allow considerations related to their future or possible future employment to compromise their independence of the parties and their legal advisors with whose cases they deal. But if the public in general, or litigants in particular, know that judges may be returning to the marketplace, the perception of possible bias will be a constant threat. That perception will be present whenever a former judge appears as advocate before a former judicial colleague. In the commercial market, too much can turn on the client's perception of increasing his chances by the use of a respectable and well-connected representation. The track record of being a judge is commercially saleable, but should not be on the market. And this was the view being expressed on behalf of the Judges' Council. They went on, it has similarities with the saleability of being a former minister or senior civil servant, the exploitation of which has not enhanced the standing of the relevant arms of public service. We do not consider that this objection of principle can be overcome by imposing safeguards or conditions. The nature of the objection is such that it remains the same whenever return to practice becomes even something which, whilst it is not the norm, is nonetheless overtly permitted or encouraged. That is because return to practice means a return to the legal market where work is done for reward, for a cause, and for a litigant. In that regard, we would draw a sharp distinction between a return to arbitrate, to mediate, or to give expert evidence. Although these tasks are routinely carried out by those in private practice, the tasks involved all require the exercise of independence, objectivity, and authority, these being the hallmarks of a judge. I've quoted that at some length because I'm going to come back to some of those points a little later. The Guide to Judicial Conduct 2013 remained fairly loyal to the long-standing convention about retired judges. It said that they could not, in return for any remuneration of any kind, offer or provide legal advice to any person. But it said a former judge may provide legal services as an independent arbitrator, mediator, and may receive remuneration for lectures, talks, or articles. The guide gave the rationale for supporting the convention as follows. Even in retirement, a former judge may still be regarded by the general public as a representative of the judiciary, and any activity that might tarnish the reputation of the judiciary should be avoided. By 2018, the prohibition on legal advice had been replaced by something vaguer and more bland. The Guide to Judicial Conduct of 2018 repeated the statement that a retired judge may still be regarded as a representative of the judiciary, but added no more than retired judges should exercise caution and are encouraged, therefore, to refer to this guidance to avoid any activity that may tarnish the reputation of the judiciary. And this statement is repeated in the current 2023 version of the guide. The earlier prohibition, still reflected in the 2013 guide, had the virtue of being clear and easy to apply in relation to the provision of legal services. It did not, however, address the question of other activities in which a retired judge might wish to engage. Serving judges have the right of freedom of expression like anyone else. This fundamental right is enshrined in international human rights treaties like the European Convention on Human Rights, as well as the Bangalore Principles of Judicial Conduct, which include a judge, like any other citizen, is entitled to freedom of expression, belief, association, and assembly. But in exercising such rights, a judge should always conduct himself or herself in such a manner as to preserve the dignity of the judicial office and the impartiality and independence of the judiciary. I suggest that any weakening of this right requires clear and cogent justification. The qualification provided in the Guide to Judicial Conduct, to which I've referred, is in substance similar to that provided in the Bangalore Principles. Few would quarrel with the principle that a serving judge should not make statements which detract from the dignity of the judicial office or tarnish the reputation of the judiciary. The difficulty in knowing what that means in practice is mitigated by the fact that the 2023 guide provides some useful specific guidance. So it states that serving judges should not comment publicly on the merits, meaning, or likely effect of government policy or proposals, the merits of public appointments, or the merits of individual cases. These conventions are said to operate variously to promote the dignity of the judicial office, the finality of judgments, and crucially, the independence of the judiciary from the other branches of government. The guide also says that, in general, for good reason, judicial office holders do not talk to the media, although it makes exceptions in the case of the Lord Chief Justice and other leadership judges. I accept that former judges may still be regarded by the general public as representatives of the judiciary, but of course they're not in fact representatives of the judiciary. It follows that their right to freedom of expression is even stronger than that of serving judges, and any erosion of it requires particularly cogent and clear justification. The 2023 guide states that retired judges should exercise caution and are encouraged to refer to the guide so as to avoid any activity that may tarnish the reputation of the judiciary. The clarity of the traditional ban has gone. It has been replaced by a plea that is vague and, I suggest, of little practical utility. For example, does it mean that retired judges may or may not talk to the media or comment on government policy, or only in certain, and if so, in what circumstances? Simply to urge retired judges to exercise caution is not very helpful. Most judges, like most lawyers, are cautious by nature. Unsurprisingly, most of the guide is concerned with guidance to serving judges. The only guidance given specifically to retired judges is, and I quote, "There is no prohibition on retired judges, provided they are no longer sitting, engaging in political activity and wider public debate. However, they should take care to avoid any activity which may tarnish the reputation," back to a familiar phrase, tarnishing the reputation, "may tarnish the reputation of the judiciary and the perception of its independence." In recent years, many retired judges have felt free to engage in all kinds of activities that would have shocked Lord Hailsham. I shall touch on some of them shortly. The culture of self-imposed silence no longer exists. This may reflect a more relaxed attitude in society to traditional norms generally. It may also reflect the fact that recent editions of the Guide to Judicial Conduct have contained no specific guidance as to what retired judges can and cannot do. So I turn to giving legal advice. Many retired judges now give legal advice, not merely as expert witnesses on English law in foreign proceedings, but also in relation to issues of English law that arise in our courts. I am one of them. I do not consider there to be anything improper in this, but not everyone agrees. Professor Richard Moorhead has written on this subject. One of his articles was inspired by an abortive application by Post Office Limited, POL, to Mr. Justice Fraser that he should recuse himself from hearing a case in the Post Office Horizon litigation on the grounds of apparent bias. At the recusal hearing, POL was represented by Lord Grabiner, KC. In the course of the hearing, he told the judge that, and I quote, "a judicial figure or barrister had looked at this." The recusal application was rejected by the judge, and permission to appeal was refused by your Treasurer, Lord Justice Coulson, who said, "Such a comment, presumably made in terrorem, should not have been made, at least without proper explanation of its relevance." Professor Moorhead said that any advice from a retired senior judge had the potential to influence the course of the case. As he put it, giving the advice was a big deal. There could have been very significant consequences. And a little later, the views of a retired Supreme Court justice would have carried real and disproportionate weight. It is clear that the question of whether retired judges, and in particular retired senior judges, should be permitted to give legal advice is one on which opinions differ. There has been a dramatic change since as recently as 2013. The long-standing conventions, stoutly defended in the Judges' Council response to Lord Faulkner's proposal, had, in my view, become unsustainable and was being ignored widely in practice. In my view, the arguments put forward by the Judges' Council Working Party in its response in support of the convention came nowhere near providing a cogent justification for the interference with the retired judge's right to freedom of speech that it entailed. In summary, the justification advanced in the Working Party report was that allowing retired judges to give paid legal advice would inevitably diminish the standing of the judiciary and weaken its independence. What was the evidence for this? The authors of the report themselves made the point that the timescale for their response was very short. They consulted and reflected the views of other judges, but not members of the wider public. Given their terms of reference and the tight timescale under which they were operating, that is hardly surprising. But in my opinion, it was a weak foundation on which to base the conclusion that allowing retired judges to give paid legal advice would diminish the standing of the judiciary in the eyes of the public, if that is what was meant. And what was the evidence that, as the authors of the report said, allowing former ministers and senior civil servants to engage in commercial activity has damaged the standing of the relevant arms of public service? Surely there are many reasons why the standing of ministers may have been damaged in the eyes of the public. I doubt whether the fact that some of them undertake paid work after they retire is one of them. It seems to me that statements of this kind without a proper evidential basis were unjustified. In my view, it is unlikely that most reasonable people would think that the standing of the judiciary is diminished by retired judges giving legal advice. I accept that, as the Working Party said, the track record of being a judge may be commercially saleable. I suspect that some judges are unlikely to get any work on retirement, whereas others are likely to be in great demand. But what is wrong with that? Why should the track record of a judge not be on the market? The authors of the report saw no objection to retired judges undertaking paid work as arbitrators or mediators, and yet there is a lively market in arbitration and mediation, in which retired judges compete with each other, as well as with barristers and solicitors and others, for work as arbitrators and mediators. Many retired judges attend arbitration and mediation conferences, at which some of them network with gusto. They may give lectures at such conferences with the aim of attracting the attention of those, mainly solicitors, who appoint arbitrators. Why is it acceptable for retired judges to act as arbitrators and mediators, but not to give legal advice for remuneration? I suggest that the distinction that the Working Party sought to draw is unconvincing. In my view, the arguments against retired judges giving legal advice are unconvincing, especially if the opinion of the retired judge is kept confidential to his or her client. The client is surely entitled to seek what he or she considers to be the best advice. That may be from an experienced specialist solicitor or a top KC or a leading academic in the field. That may put the client at an advantage over his or her opponent. A similar advantage may be derived from seeking advice from a retired senior judge. But if the advice remains confidential, it is difficult to see how the retired judges giving it risks damaging the reputation of serving judges or the justice system as a whole. What about the risk that the client may seek to gain an advantage by deploying the advice in referring to it or even showing it to his or her opponent during negotiations or even to the judge in court? I'm not persuaded that this possibility is a reason for denying retired judges the right to give legal advice. So far as I'm aware, it is only very rarely that a party seeks or has sought to deploy a legal opinion in court, however eminent the author of the opinion may be. As Lord Justice Coulson said, or at least implied, such an opinion is irrelevant. Courts are not interested in lawyers' opinions. They're interested in the legal submissions of the parties and their representatives. I accept that not all judges are as robust as Mr. Justice Fraser and Lord Justice Coulson were in the POL case, but in my view, the remote possibility that a party who has the benefit of a favorable opinion from a retired senior judge may disclose it in support of their case can, for all practical purposes, be ignored. It is not sufficient, and not a sufficient, still less a cogent reason for depriving the party of the opportunity of obtaining legal advice from a retired judge or for prohibiting the judge from giving such advice. I say that for two reasons. First, unless there is a change in litigation culture, the possibility of parties deploying opinions that they've obtained from retired judges will continue to be remote. In the real world, therefore, the spectre of the views of retired senior judges being disclosed and carrying real and disproportionate weight so as to influence the outcome of a case can, I think, be dismissed. Secondly, if I'm wrong about that, or there were to be a change in litigation culture, the solution to any perceived problem would not be to attempt to prohibit retired judges from giving legal advice. Rather, the Bar Council and the Law Society, as regulators of their respective professions, should prohibit barristers and solicitors from deploying an opinion that they've obtained from a retired judge before the judge who is hearing the case. I turn to advocacy. In my view, advocacy, especially oral advocacy, is different. Most judges will attest that they have experienced cases where, on reading the papers, they formed a provisional view one way, and following good oral advocacy and testing of the arguments in the crucible of oral submissions, they changed their minds. I certainly did. The oral submissions of a retired senior judge may carry disproportionate weight, especially if the judge hearing the case is junior and inexperienced. But even some experienced judges may be somewhat intimidated and overawed by the submissions of a retired senior judge. Some might be robust enough to withstand the pressure, but I suggest that others may not be able to do so. The objection to permitting retired senior judges to undertake oral advocacy on behalf of their clients is that intimidating or unduly influencing judge is damaging to the integrity of our justice system and tarnishes the reputation of the judiciary. By the judicial oath, judges undertake that they will decide cases without fear or favor, affection, or ill will. The risk of judges being intimidated or unduly influenced would be real if senior retired judges were permitted to undertake advocacy. I accept that there is a risk that some judges, particularly inexperienced judges, may also be intimidated by powerful advocacy of top casees, but that risk is unavoidable. I have personal experience of the risk of a senior judge putting a more junior judge off his stride. I was in a panel of potential jurors who were to be selected to try a case in the Crown Court. When my name was called out, the judge looked up at me and said, "This man is well known to me, he should stand down." At this point, the woman who was standing next to me, wondering whether she was going to be admitted to the jury, said to me, "What you done then?" Well now, by this time, I was a Lord Justice of Appeal, and I had sat with the judge for 3 weeks in the Court of Appeal Criminal Division. He was not otherwise known to me. It was clear to me that he had seized on an excuse to avoid having me on his jury. He did not want me judging his work. It is true that equality of arms, equality of arms is impossible to achieve in litigation. One party may be able to afford to engage a fleet of the most expensive top lawyers, where the other is represented by one young barrister and one solicitor. Our system tolerates such inequalities, so why should it not be possible for one party to have the benefit of the advocacy of a retired senior judge when the other is not in that position? Well, I think the answer is that there is a qualitative difference between the two scenarios. It has long been accepted that parties are entitled to engage the solicitors and barristers of their choice, and that includes barristers or solicitors who even those who sit as deputy High Court judges, some of whom may have had many years of experience in their judicial roles. I do not consider that drawing the advocacy line at retired senior full-time judges is arbitrary. Most deputy High Court judges are advocates who sit as part-time judges. There is a real difference between a practicing advocate who sits as a part-time judge and a retired judge who, before retiring, sat as a full-time judge in a senior echelon of the judicial hierarchy. What about written submissions? They're a form of advocacy. Indeed, in heavy civil litigation, written submissions may, in many cases, be more significant than oral advocacy. Should retired senior judges be permitted to put their names to the written submissions that are received by the judge hearing a case? In my view, the answer is no, for the same reasons as retired senior judges should not be permitted to make oral submissions. There is no difference in principle, although it may be said that a judge is more likely to be influenced by seeing and hearing a retired senior judge than by reading his or her written submissions. I acknowledge that there is a difference, but at most it is one of degree. When I move to the world, beyond the world of litigation, we have moved a long way from the austere world reflected in Lord Hailsham's comments in 1970. Even serving senior judges frequently give lectures and participate in seminars on all manner of legal subjects. They're encouraged to do so. The role of a UK Supreme Court justice includes, and I quote, promoting understanding of the justice system, the Supreme Court, and the rule of law, both inside and outside the court, for example, through lectures. And all Supreme Court justices give lectures. I know that Lady Hale has done, I have done, and I think they probably all of them do. The guidance given to retired judges as to what they may do is jejune, to say the least. To say that they should exercise caution to avoid any activity that may tarnish the reputation of the judiciary is unhelpful unless it is supported by specific examples of what activity would or might tarnish the reputation of the judiciary. In my view, there is nothing objectionable about retired judges speaking or writing publicly about legal issues of the day, including interesting current cases. Why should a retired senior judge not comment in a lecture or panel discussion in a seminar on legislation or an important decision of the courts? There's a real public interest in knowing what retired judges, especially senior retired judges, have to say on such matters. Their views are likely to be at least as interesting and valuable as those of practicing and academic lawyers. How could their comments tarnish the reputation of the judiciary? Mere criticism of court decisions or legislation cannot reasonably be thought to tarnish the reputation of the judiciary. Criticism of the decisions of the courts is standard fare of appellate courts. Nobody would suggest that such criticism damages the reputation of our judicial system. I accept that scurrilous or outrageous criticism by serving or retired judges might do so, or personal attacks on the competence of former colleagues or government ministers. But I suggest that it is axiomatic that comments are overwhelmingly likely to be measured and responsible. If they're not, I would expect the current Lord Chief Justice or President of the Supreme Court to strongly criticize the author of the comments. These far-fetched possibilities do not justify interfering with retired judges' right to freedom to express their views about legal issues. The current guide on judicial conduct warns serving judges against dealing with the media. It says, in general, for good reason, judicial office holders do not talk to the media. Judicial office holders cannot talk about the cases they or their colleagues hear, and it is important to maintain the separation of powers and independence and not comment on matters of controversy or those that are for Parliament or government. There are circumstances when cautious engagement is possible. For example, a leadership judge, like the Lord Chief Justice, may feel the need to say something of general importance to correct misapprehensions that have been expressed in the media, which are potentially damaging to the integrity of the system. but these circumstances are likely to be rare. Like many retired judges, I have often been asked by the media since my retirement to comment on topical legal issues, typically a court decision or a government proposal. I have usually refused. Oddly enough, it was only today I received a request by a journalist to comment on the assisted dying bill, which is very topical. I said I was too busy. But a small number of us are bolder and say yes. Most retired judges would not venture outside the world of which they have some knowledge and in which they feel comfortable, namely the law and justice. But some are willing to travel further afield. Lord Sumption, I had to mention him, I suppose. Lord Sumption is a professional historian and has views on many issues of general interest and importance, which he is happy to express publicly, either by writing pieces in national newspapers and elsewhere, or by speaking. For example, in 2023, he explained why he thought that the government was wrong to fight COVID-19 with lockdowns. In December 2023, he stated that he favored decriminalizing assisted suicide, despite the risks to the old, infirm, and disabled that this would entail. His statements were widely reported in the media. He has also expressed views on all manner of what might be described as political and economic issues, including whether Brexit was wise. It is highly unlikely that a serving judge would have thought it appropriate to do this kind of thing. But what is the objection to a retired judge doing so? In my view, there is none in principle. I say in principle because there was one occasion when, surprisingly, in answer to a question on assisted suicide after one of his Reith lectures in 2019, Lord Sumption said that there was no moral obligation to obey the law, which should be, he said, broken from time to time. I think this remark was unfortunate, but it is far-fetched to suppose that most reasonable people would regard an isolated comment of this kind as reflecting the views of the judiciary as a whole. I do not consider that this comment provides any real basis for concluding that there is a real risk that what Lord Sumption has been saying will tarnish the reputation of the judiciary in the eyes of reasonable people. His comment attracted a great deal of publicity. Like the media reaction to Lady Hell's letter about the International Court of Justice ruling that I mentioned at the outset, Lord Sumption's comment shows how much public interest there is in what retired senior judges have to say about legal issues, and therefore how careful they should be in what they say. I turn to inquiries. We're living in an age of statutory and non-statutory inquiries. The subjects of inquiries vary enormously. They range from factual inquiries, what happened inquiries, to inquiries which concern questions of socio-legal policy, where political implications are involved. Some of the most eye-catching inquiries have been those arising from alleged failures of government, the political system, or the organs of this state. A good example of an inquiry that falls into all of these categories is the UK COVID-19 inquiry. These inquiries are often complex and raise important issues of great public interest. They call for robust but sensitive handling. Many of them have been chaired by serving or retired senior judges who are used to and skilled at assessing evidence and dealing with complex issues, and they are institutionally independent and command respect. In 2004, Sir Jack Beatson gave an erudite and thought-provoking lecture entitled, "Should Judges Conduct Public Inquiries?" He said that judicial skills may not necessarily be the most appropriate where an inquiry concerns the relationship between government and Parliament. He concluded that judges should only be asked to conduct inquiries with a strong political flavour, where the matter is of vital public importance and there really is no alternative. And he said they are given protection, for example, by creating the institutional framework of an appropriate system for appointing the judicial members of inquiries. He was addressing the position of serving judges and did not consider the position of retired judges separately. But his reasoning suggests that he would have adopted the same approach to the appointment of retired judges to chair inquiries. On the basis of Sir Jack's reasoning, I suggest that no judges would ever be appointed to conduct inquiries with a strong political flavour, because it would always be possible to find an alternative. But this approach has not been adopted. Senior retired judges have been appointed to conduct inquiries with a strong political flavour. Recent examples include the contaminated blood inquiry, Mr. Justice Langstaff, the Grenfell inquiry, Sir Martin Borbick, and the COVID-19 inquiry, Baroness Hallett. I'm not aware that there have been any criticisms to these appointments on the grounds that the retired judges were not suitable to conduct the inquiries that they were appointed to chair. I see no reason why retired senior judges should not conduct inquiries, even ones with a strong political flavour. Their skills in conducting a fair and efficient process, evaluating evidence, and expressing their findings and conclusions clearly are invaluable in a complex inquiry. They are used to dealing with subject matter which does not lie in their comfort zone, for example, technical evidence. If necessary, they can be assisted by expert witnesses and counsel. Diaries and memoirs. I start with diaries. So far as I'm aware, and I may be wrong, but so far as I'm aware, the only judge, certainly the only senior judge, who has published their diaries is Lord Hope of Craighead. The diaries contain much that is mundane and of no general interest. I'm sure he will forgive me for saying that. But they also contain revelations of Lord Hope's views about his colleagues and details of the Supreme Court Justices' discussions when they were considering how to decide an appeal. It may be said that there is a real public interest in knowing about the political and philosophical views of judges who decide important cases, especially cases which are of general public importance, and that being given access to material which enables the public to see what their views are is in the public interest. I do not accept this. In my view, fascinating though they may be to some people, the private musings and records of what a judge thinks about his colleagues and about political issues of the day and of their deliberations when deciding cases should remain private. It can be no cause for surprise that judges have different personalities from each other and a range of political and philosophical views. It can serve no useful purpose to learn, for example, that Justice X usually votes Conservative or that Justice Y usually votes Labour. As for accounts of the deliberations of the justices, it is surely obvious, and I always assume, that these are confidential. If judges know or believe that what they say to their colleagues when they are discussing how a case should be decided is likely to be published, that is bound to have a seriously inhibiting effect on what they say during their discussions. That is surely bad for justice. In my view, the Guide on Judicial Conduct should spell this out. What about memoirs? I should at once declare my hand. Like many other retired judges, I have written a memoir. In my own memoir, A Judge's Journey, I have described my career as well as my personal life. I have been by no means the only judge to have written a memoir, as I say. I think retired judges should have a free hand to say whatever they want in their memoirs, provided that they do not break the law in doing so. In preparing this lecture, I come now to regulation. Is there some water here? Thank you. Thank you very much. In preparing this lecture, I've been assisted by two excellent articles by academics. The extrajudicial, thanks very much. Thank you. The Extrajudicial Voice by Connell Mallory and Helene Tyrrell, and Work in Judicial Retirement, a Policy Report by Patrick O'Brien and Ben Yong. The authors of the second paper record that most of the judges and retired judges whom they interviewed expressed the view that regulations were unnecessary because judges would not welcome them, or that judges already knew how to behave. The authors disagree with most of their interviewees and conclude that some form of regulation is required. They recognize that the prospect of regulation of former judges is, quote, intrusive and illiberal, and that, quote, weighty reasons are required to justify it. In their view, such reasons exist. In summary, the reasons are that there is a risk that what retired judges do or say, whether providing legal services or not, will give rise to the appearance of bias and create a risk to the legitimacy or reputation of the judiciary by association. They recommend new rules for judicial retirement should be put out to a consultation process involving judges, retired judges, regulators, and officials. Their paper contains what they call sample non-binding rules. This is not the place to describe the draft rules in any detail. The authors have since elaborated on their views in their very recent public law article, The Decline of the Judicial Retirement Convention, 1950 to 2020. I agree with them that weighty reasons are required to justify regulation of retired judges. The question is whether such reasons exist. On this, opinions will differ. Messrs. O'Brien and Young say that the provision of legal advice and legal opinions raise sufficient concerns about apparent bias and perception that former judges who wish to engage in them should only do so if they hold a practicing certificate and accept professional regulation. They cite the use of legal advice provided by Lord Newburgh, and it was Lord Newburgh who had provided the advice to which Lord Grabiner made fleeting reference. The legal advice provided by Newburgh as part of the submission in the Post Office litigation as an example of the difficulties such advice can lead to. As I've said earlier, in my view, the solution to this problem, if it is a problem, lies in regulation of barristers and solicitor advocates, and not saying that retired judges should not be allowed to give legal advice. They also cite the example of the application to Mr. Justice Peter Smith. Mr. Justice Peter Smith had to come in at some point to recuse himself from hearing a case which involved a partner of the solicitor's firm Addleshaw Goddard. The application was rejected by the judge but allowed on appeal. It arose from the fact that while still in office, the judge had engaged in discussions with the firm about the possibility of his joining them after his retirement. I suggest that most serving judges would instinctively know that it was inappropriate while still in office to start negotiating with a firm with whom they were going to work post-retirement. In the unlikely event of that occurring, the judge would surely know that he should recuse himself from sitting on a case which involved that firm. In summary, Messrs. O'Brien and Young say that regulation is required because the provision of services by retired judges give rise to risks to our justice system and the rule of law in different ways. I've mentioned some of these already. They might also have added that such risks can arise from retired senior judges sitting, say, in the courts of countries which have poor human rights records. The argument would be that by sitting in such courts, the retired judges are somehow running the risk of causing damage to our justice system and the rule of law. But that controversial argument, I'm afraid, is for another day. Messrs. O'Brien and Young say that it is anomalous that former judges should be able to provide legal services without any form of regulation. It is insufficient, they say, to rely on traditional conventions. They propose that first, conduct guides for the judiciary should include detailed but non-binding guidance on conduct and work in retirement. And secondly, that former judges should be required to apply for a practicing certificate from the Bar Standards Board or the Law Society if they wish to work in retirement. In my view, the enforcement of non-binding guidance is a contradiction in terms. And yet, if guidance is not to be enforced, in what sense would retired judges be subject to regulation at all? It may be that the only way in which retired judges can be regulated is by legislation, but that will be an extreme measure to tackle the perceived problem. I've earlier said that I think the judicial guide should give more detailed guidance as to what judges may properly do in retirement. To that extent, I entirely agree with Messrs. O'Brien and Young. But guidance is fundamentally different from regulation. I'm not seeking to make a semantic point here. Regulation is effected by regulators who exercise powers with which those who are regulated are required to comply. Following non-binding guidance is a voluntary act. The days of Lord Hailsham's analogy between judges and priests have long gone. The position of retired judges has evolved to a point from which I believe there will be no going back. Despite the concerns expressed by Messrs. O'Brien and Yong, I believe that there is no evidence of a widespread dissatisfaction with the current unregulated situation. There will always be the possibility that a few maverick judges may behave in a way which the overwhelming majority would deplore. But non-binding, unenforceable regulation, whatever that means, would not prevent that. So, I conclude in this way. There are many reasons why judges wish to do more than cultivate their gardens once they retire. I would expect the unifying factor to be that most of them wish to continue to be actively engaged in life and to use their intellectual powers and skills and experience if they're still able to do so. Some of them wish to learn a new skill or study a new subject and have nothing more to do with the law, but most wish to be involved in the law in some form or another. For example, by arbitrating or mediating, conducting inquiries, giving legal advice, lectures, writing or teaching. I accept that I am party pre, but I believe that retired judges have much of value to offer. I'm not aware that the concerns that have been expressed in some academic circles are shared by the wider community to any significant extent. Any concerns can and should be met by giving more detailed guidance than is to be found in the current guide to judicial conduct. In my view, those who would wish to curtail the freedoms of retired judges have not provided clear and cogent justification for doing so. I think I've overrun by 2 minutes. Thank you.
Lord Dyson, thank you very much. You've graciously said that you would take a few questions, notwithstanding that the bubbles or the wine is getting warm upstairs. So we have got time. We've got a couple online. Could I please ask, if you do have a question, raise your hand and ideally stand up and give your name before you ask a question. Could I just remind this is not an opportunity to have a second lecture and keep your questions short? Thank you very much. Would anyone like to ask a question? While you're all... Oh, no, Sander.
Benefit of the mic. The judicial retirement age has recently returned to 75. I wonder if, in your view, the point at which the unfortunately termed statutory senility, which I don't agree with, the point at which that comes into effect has any bearing on your views about returning to work after retirement?
Well, I can answer that very shortly. No, it doesn't. I really don't think it has any bearing at all. Clearly, if judges had to retire at 70, they'd be more likely to want to do things post-retirement and for a longer period. But I don't think it affects any of the points I've been making.
Anybody else? I've got, yes.
Andrew McFarlane, I'm serving judge. Pleasure to see you, John, on top form. I think it's been extremely important and valuable for you to address this topic in the way you have. You opened the box and got each of the elements out and looked at them in a particular way and given us your view. I suspect the controversial element will be giving legal advice and where the line is within legal advice. Do those giving legal advice, once the constitution of the tribunal is known, and the Supreme Court or the Court of Appeal advise on the views of what the members of the court might be, do they give general legal advice or not? But I think that's the controversial area. The question is, and I may be wrong about this, but I think judges of my generation certainly were required to give an undertaking when we took the job, which was that we wouldn't return to practice. And that certainly, if it wasn't an undertaking, it was an understanding. And it's one that I've always had in mind, and I've always therefore regarded as returning to give legal advice, returning to practice in that way, as being something that just wasn't on the radar screen. But I don't know if you've considered that or whether you think that I'm wrong.
No, I don't think there are rights and wrongs about this. But as I said, I have given legal advice and do give legal advice. In fact, well, I better say no more about that because I might get into trouble. But I mean, that is a point of view. I fully understand it and respect it. I don't remember, but it's a very long time ago. I don't remember giving any sort of undertaking, and I don't actually even remember, but it, as I say, it's a long time ago, any understanding that I would not undertake any legal work for remuneration. I clearly understood, always understood, that I would not ever be an advocate in court, and for the reasons that I indicated in the lecture. The argument about saying that one shouldn't give legal advice in the confidential way that I think it should be given, as I say, that's a matter, I think, for the professions, because they can regulate that and control it. But if the legal advice is given, is kept under wraps, but simply as between the people who instruct you and their clients and you, then I don't see a problem. But I can understand that you might say, well, if I were to be asked, well, being told that the tribunal that's going to hear this appeal in the Supreme Court consists of Justice A, B, and C, and D, and E, and to tailor your approach to those people, and I can see that could be said to give an advantage. But a lot of experienced silks, they know exactly the form about Justice A, B, C, and D. And they know who are the bleeding hearts and the tough ones. So I'm not sure. This is another example of a point I made earlier on, that these are matters of degree. I don't see these things as being black and white questions. I'm afraid that's a rather woolly answer to your question, but it's the best I can do without notice.
I've got one online, but I can take one more in here. No, please.
Thank you. John Uff, former recorder, chairman of various tribunals. One stage in my career, I wrote a number of papers about professional ethics. And having looked at the subject in this country, I, of course, discovered that in other countries, particularly the USA, they had gone a great deal further. And I recall on the very subject of retired judges and their roles, one of the debates that was hotly contested was whether, when judges were appearing as advocates in court, the judge should call them judge. My question is, should we be concerned with what goes on in other countries, particularly the Commonwealth?
Well, I'm afraid you'll have to be a bit more specific. What particular thing that goes on in the Commonwealth are you concerned with?
Well, practices in many countries, and certainly my experience in doing arbitrations in many different countries, is that the views about the role of retired judges differs very significantly, and particularly in Australia, and I think the US is the extreme case. As I say, there is plenty of experience of retired judges simply going back to legal practice and acting not just as experts, but as advocates.
Well, I've said my piece, really. I think that senior retired judges should not appear in court for the reasons I gave, but I see no problem with giving legal advice so long as it is not deployed as it was deployed by Lord Grabiner.
Ladies and gentlemen, 40 years have just flown past The very first case I ever did, John Uff was on one side and John Dyson was on the other. Absolutely perfect. You have also heard me described by Lord Dyson as robust. I'm very proud of that. Ladies and gentlemen, Lord Dyson.